Let's begin with the history of Indian Evidence Act 1872. In order to trace the history of the law of evidence in a country, we have three different periods to study: the ancient Hindu period, the ancient Muslim period, and the British period. According to Hindu law, proof was of two kinds, divine and human. The former consisted of ordeals and the latter of witnesses, documents, possessions, and inferences from circumstances. On the other hand, according to Muslim law, the slave dynasty established by Qutbuddin came to an end. That is, when the Muslim rulers had well established themselves in India. The Islamic idea of justice was also well established in the country. There was no systematic or complete law regarding the evidence in India. Non-Muslims, especially Hindus, were subjected to Islamic law. Their affairs were regulated according to the principles of their own religion, especially in the matters of inheritance, marriage, etc. That is, in matters which we would refer to as subject to the personal laws. The Hindu law was applied to Hindus with the aid of Pandits or Shastris, who were attached to the courts. But the Islamic criminal law applied to all equally. When the Britishers came to India during the British period 1835 to 1855, at least 11 enactments in this area of law were dealt with. In 1868, a draft was prepared by Sir Henry Sumner Maney, which was found unsuitable for the country. Later, Sir James Stephen in 1872 prepared the bill for the Act as in present day, who was entrusted with the same work in 1871. Finally, Indian Evidence Act 1872 was drafted by Sir James Fitzjames Stephen, popularly known as Sir James Stephen. You can see the photograph, luckily we do have it. Before moving further, let's do one quote of the day. Every efforts make next effort easier and more fruitful, and success is sum of all small efforts repeated day and night. So, if you learn one section, you try to learn another section, and slowly your efforts will make you learn all Bear Act by heart. Object of the code. The object of the code is to facilitate the judge to form a rational conclusion as to the existence or non-existence of the disputed fact. And law of evidence comes under adjective laws, because law of evidence provides that how to reach before the court, how to proceed the court, and how to establish a claim before the court. It means law of evidence deals with rights as well as procedures. Introduction. The word evidence is derived from the Latin word evident or evidere, which means to prove, to discover clearly, and it is not exhaustive in nature. Indian Evidence Act is lex fori, which means rule of the place of law, that is, the law of the land. It is an adjective law. Law of evidence is basically a procedural law, but some of its provisions do come under the substantive law. So we can say it is more procedural and less substantive, but a combination of both. Let's cover some definition of Indian Evidence Act. As per the words of Taylor, the word evidence includes all legal means exclusive of mere arguments which tend to prove or disprove any matter of fact, the truth of which is submitted to judicial investigation. And in the words of Bentham, any matter of fact, the effect or tendency of which is to produce in the mind a persuasion, affirmative or disaffirmative, of the existence of some other matter of fact, which means to persuade a person It is easy to study the subject when we know the contents of the book before opening the book. So, before opening the book of Indian Evidence Act 1872, let's check what the contents are. It is divided into three parts: Part 1, Part 2, and Part 3. In Part 1, it talks about relevancy of facts. It has 2 chapters only. In Part 2, it explains us about on proof, and it has 4 chapters on this topic. In Part 3, it explains us regarding production and effect of evidence. It has total 5 chapters. So, it concludes that Indian Evidence Act has total 11 chapters in all. It will be easy to learn all the sections of Indian Evidence Act if you learn to draw this chart. Indian Evidence Act 1872 divided into 3 parts, and then the part 1 you write down, it is relevancy of facts. In part 2 you can write down proof, and part 3 production and effect of evidence. We come to part 1, it is relevancy of facts. This is divided into 2 parts again. The part 1 contains chapter 1 preliminary bearing section 1 to section 4, and in part 2 relevancy of fact, it is contained under section 5 to section 55. Now we come to another part 2 on proof. We already know that it contains 4 chapters, and these are chapter 3 facts need not be proved as per the provision of section 56 to 58. Chapter 4 oral evidences as per the provision of section 59 to 60. Chapter 5 documentary evidence as per the provision of section 61 to 90A. And chapter 6 exclusion of oral by document as per the provision of section 91 to section 100. Now we come to the third part of Indian Evidence Act, production and effects of evidences. Which evidences? Which we already covered in second part. Now the third part is explaining us its effects. Well, we already know it has 5 chapters. Let's see which of them they are. Chapter 7 burden of proof as per the provision of section 101 to section 114A. Next is chapter 8 estoppel as per the provision of section 115 to section 117. Chapter 9 is regarding witnesses as per the provision of section 118 to section 134. Chapter 10 examination of witnesses as per the provision of section 135 to section 166. And the last one, chapter 11 improper admission and rejection of evidence as per the provision of section 167. That's it. If you learn this chart, you will quickly learn the distribution of section, and half the job is done for learning Evidence Act with all of its section. Now we know that Evidence Act is divided into 3 parts. Let's take the first part first, relevancy of facts. It has 2 chapters, chapter 1 and chapter 2. Let's move step by step. We are going to take up chapter 1 first, which is preliminary, section 1 to section 4. Chapter 1 Preliminary. Section 1 Applicability. Section 1 says it extends to the whole of India except state of Jammu and Kashmir as usual. Evidence applies to all judicial proceedings in or before any court, including court-martial. Now, when I say court-martial, it is subject to condition apply, which means in court-martial, it does not apply to court-martial convented under the Army Act, the Naval Discipline, the Indian Navy Discipline Act 1934, or the Indian Air Force. So your answer to the question, does it apply to court-martial, is yes, but it does not apply when the court-martial is convented under the Army Act, Indian Navy Discipline Act, or the Indian Air Force Act. Let's check it further. Indian Evidence Act 1872 is not applicable to affidavits presented to any court or officer. Number 2. The proceedings before an arbitrator or the tribunal. And not to forget that commencement of Act, it shall come into force on the first day of September 1872. Further, let me tell you that judicial proceeding is not defined in Indian Evidence Act. Judicial proceeding is defined in Section 2, Clause I of Criminal Procedure Code 1973. Judicial proceeding includes any proceedings in the course of which evidence is or may be legally taken on oath. Okay, so now understand what's non-judicial proceedings. Well, they are proceedings by district magistrate conducting inquiry in a crime. 2. Proceedings by tribunals or arbitrations. 3. Departmental proceedings for disciplinary action. 4. Inquiry by magistrate into cause of death under Section 176 of Criminal Procedure Code 1973. Now we come to Section 2, which is repealed, deleted or removed. Since it's deleted, we do not need to learn it. Where do I get this from? Well, when you open the Bare Act, you can see it's written Part 1 over here, the relevancy of fact is over here. You can see Chapter 1 preliminary written over here. The short title, Section 1 says, the Act may be called Indian Evidence Act 1872. And it explains where does it extend. We have already covered that. And Section 2, I just told it is repealed, so we do not need to learn it. Now we come to Section 3, which is interpretation cause, which means Section 3 defines words. The first word we learn is court. Court includes all judges and magistrate and all persons except arbitrators legally authorized to take evidence. The word fact is also explained under Section 3 of Indian Evidence Act. Fact means and includes 1. Anything, state of things, or relation of things capable of being perceived by the senses. And second one, any mental condition of which any person is conscious. Let's understand the first word. Anything. Anything means anything. Ahmad Khan is playing cricket. It's a fact. Roshni Kapoor is watching YouTube. It's a fact. Rameshwar Kumar is studying law. It's a fact. So it's anything. Now the second word, state of things. Water is cold. The coldness of the water is state of thing. Capable of being perceived by the senses. You're watching this YouTube channel. You're watching it through your eyes. You can sense it. You're hearing my voice. You're hearing this lecture through your ears. That is senses. So, capable of being perceived by senses is covered. Second part, any mental condition of which a person is conscious. Now, mental condition is if a person thinks Salman Khan is a bad man. So, the mental condition of that person is he considers Salman Khan as a bad man. Salman Khan is a good person. Now, the mental condition of the person is he considers Salman Khan as a good person. Now, there are illustrations means examples, which are given in the Bare Act. These are very important because one of them does come in judicial examination. Let's cover them out. 1. That there are certain objects arranged in a certain order in a certain place is a fact. Let us create an example out of this. In Doom Cinema House, Mumbai, the first 4 rows are of silver, the second 4 rows are of gold, and the last 4 rows are of platinum. So here we can say the sitting arrangement in certain order is a fact. Now let's take up the second one. B. That a man heard or saw something is a fact. Let's create an example for this. I and my friend Krishna went to cinema house. My friend Krishna heard that Shah Rukh Khan is sitting in the first row. Then I immediately went in the front and I saw Shah Rukh Khan sitting in the first row. My friend heard Shah Rukh Khan is sitting in first row is a fact. I went and saw Shah Rukh Khan sitting in the first row is a fact as well. So to hear or to see something is a fact. Now let's take up a third illustration. That a man said certain words is a fact. For this we can create an example. When we came out of the house, one person said this is a boring movie. The person said certain words that the movie is boring is also considered as a fact. Now let's take up next illustration. That a man holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation is a fact. Now, how do we explain this? That a man holds a certain opinion. When a person says, I don't like Shah Rukh Khan, he seems to be selfish person. Here, the opinion of the person that he thinks that Shah Rukh Khan is a selfish person is a fact. Next thing, has a certain intention. When a student says, I don't like math subject, I feel like killing this subject. So the intention of a person, of the student, killing of math subject is a certain intention of the student. And anything done in the furtherance of his intention or opinion will be considered whether he did it in good faith or fraudulent. That is also a fact, that he did it in good faith or he fraudulently did something. That is also a fact. Next, it says uses a particular word in a particular sense, which means that sometimes a person uses the word lovingly or the same word in a very threatening tone. The illustration goes on to explain that the person is or was at a specified time conscious of a particular sensation, means at a particular time when a person was aware through some sense. Now we come to the last illustration, E. That a man has a certain reputation is a fact. Reputation everybody knows, so I don't need to explain it. Next word explained under section 3 of Indian Evidence Act is relevant. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of facts. Let's take up an example. Salman Khan is a superstar. He has a bodyguard named Shera. So one fact that Salman Khan is a superstar is relevant to the other that he has bodyguard Shera. So it is relevant. They both are connected. Next word is facts in issue. As per the provision of section 3 of Indian Evidence Act 1872. The expression facts in issue means and includes any fact from either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability, disability, asserted or denied in any suit or proceedings necessarily follows. To understand this, let's take up an example. Salman Khan was charged for hit and run case. There was an accident last night. It's a fact. There was an accident that caused death of people sleeping on the footpath. It's a fact. Now the fact in issue is whether Salman Khan was driving that night, last night or not. I hope that makes it very clear example regarding fact in issue. Whether it exists or it does not exist. Asserted or denied by the accused is the matter to be searched, discussed and decided on the basis of evidence. The Bare Act has further given explanation to it. Let's read that also. Whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. Now let's take up some illustrations in facts in issue. If A is accused of the murder of B, then what are the facts in issue that we are going to see? At his trial, the following facts may be in issue. That A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A at the time of doing the act which caused B's death was by reason of unsoundness of his mind incapable of knowing its nature. So, do not forget to remember all these facts which may be in issue. This may be a question in a judicial examination. With question, what will be fact in issue when A is accused of the murder of B? Next word explained under section 3 of Indian Evidence Act is document. Document means any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means intended to be used or which may be used for the purposes of recording that matter. So, document in Evidence Act does not mean something written on a piece of paper. It means anything, any mark, any kind of indication written anywhere. Let's take up some illustration. Illustration means examples. A writing is a document. Words printed, lithographed, or photographed are documents. A map or plan is a document. An inscription on a metal plate or a stone is a document. A caricature is a document. Let me try to explain these. Something written is a document, means anything which is written on a paper. Lithographed are words, photographed, signs written on a stone. It is known as lithographed. Photos are also considered as document in Evidence Act. Any kind of map or a plan, it's also known as document in Evidence Act. Inscription on metal plates. Well, do you remember in olden days and even now some of the people or in hotel people, they get their name inscripted on the vessels, on the plates, on the bowls or the cups? Yes, that's inscription and that's also considered as document. Caricature. Well, it's a kind of drawing, not just the photograph, anything drawn. It's also considered as a document in Indian Evidence Act. Finally, we come to the word evidence as per the provision of Section 3 of Indian Evidence Act 1872. Evidence means and includes 1. All statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. 2. Or subsection 2 of section 3. All documents including electronic records produced for the inspection of the court. Such documents are called documentary evidence. So the word evidence has twofold meanings. 1. Statement given before the court as oral evidence. 2. Documents in any form, in electronic form, anything, is considered as documentary evidence. In short, evidence means and includes oral evidence and documentary evidence. Presently, we are just going to understand the meaning of evidence. We are going to cover it in details at later stage. Next word that is explained under section 3 of Indian Evidence Act 1872 is proved. It is explained as a fact is said to be proved when, after considering the matter before it, the court either believes it to exist or consider its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. It means that when a matter is brought before the court, the fact is required to be proved either by making its existence so probable means likely to happen, that a prudent man means it can be compared with a wise man, under the circumstances, belief. Supposition means uncertain belief that it exists. The fact exists means a fact proved. The next word which is given in the interpretation clause is disproved. A fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. This means that a fact is said to be disproved when a given fact is considered that it does not exist. So the fact is disproved. The next word explained in the interpretation clause under section 3 is not proved. A fact is said not to be proved when it is neither proved nor disproved. Do cover these words: proved, disproved and not proved. One of the question might come in judicial examination. Let me try to explain it once again. If a given fact is proved, definitely it is proved. When a given fact is not proved, then that thing is called disproved. But when a situation arises that a given fact is neither been able to proved or nor been able to disproved, then that situation is called not proved. Now we come to section 4 of Indian Evidence Act 1872. It speaks about may presume, shall presume and conclusive proof. Let's take up the word may presume first. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. May presume means to assume, to suppose something. May presume means it depends upon the court whether it is going to presume it or not. Means it is upon the discretion of the court. The next word, as per the section 4 of Indian Evidence Act, is shall presume. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. Previous word was may presume, which means it is optional, it is discretion of the court to whether to presume or not to presume. But over here, it shall presume means the court is going to presume it, assume it to be true. For example, a map of China, a map of Bangladesh, presume it to be true until and unless it is disproved, which is also given over here. Now next one is conclusive proof. When one fact is declared by this act to be conclusive proof of another, the court shall on proof of the one fact regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. For example, where everybody knows that Shera is the bodyguard of Salman Khan. Now, we don't need someone to prove it or disprove about it. It is a conclusive proof that everybody knows that Shera is Salman Khan's bodyguard. With this, we come to the end of chapter 1. Till we meet again in the next lecture, take care of everyone and don't forget to respect your parents.